like to say a few words on that topic to express the other side of the story. I have great respect for our senators, and the beauty of our country is that we have the opportunity to discuss this rationally instead of hurling insults at each other. And we don't throw chairs at each other like members of parliament do, so we're a much more civilized society. I want to let you know that both of my parents lived under Nazi rule in Poland during World War II, and they were lucky enough to have escaped Eastern Europe before it was under Soviet domination. So I am particularly sensitive to that topic of freedom, and it's a personal thing with me and my family. I'd like to make a statement, and you evaluate it. God is a bird. Let me repeat that. God is a bird. If we take one phrase out of the Bible where it says God will take you under his wing, you have to assume that God is an avian. Now, I think the same principle applies to taking a single phrase out of our Constitution and binding us down to that with such strict observance that it becomes an absurdity, in my opinion. Each one of us raised our hand and swore an oath to uphold the federal and the state of Idaho constitutions. And I look at those as documents that prescribe certain ideals and ideas and generalities. And to stick me down to one particular verse that says I can or cannot do something because of this particular instance that the writers of the Constitution had no idea would be misinterpreted in the future, to me just doesn't make sense. Let me give you my point of view. It says, Article 4, Section 9, which has been referred to, it shall have no power to legislate on any subjects other than those specified in the proclamation. Now, first of all, if you really want to get technical, and apparently we are getting technical because we're bound by this particular clause, House Concurrent Resolution 1 is not legislation. It was not a bill. A bill gets started in one chamber or one house, gets debated, gets passed, gets moved over to the other chamber, gets approved, and guess where it goes? To the governor's office. He has 5 days to do one of three things. He can ignore it and it becomes law. He can sign it and it becomes law, or he can veto it and it becomes law. Then the legislature, if they're still in session, and this is something that needs to be fixed, as Senator Vick indicated, we need to have the power of veto over the governor if we have a 2/3 supermajority, and we are the representatives of the people. Okay? Now, I heard reference earlier that the Senate didn't want to make the House mad. You know, I don't care who in the legislature is mad. The House didn't want to make the people mad. The people were sending us thousands. Okay, the House and the Senate all work for the people. We're elected every 2 years, not like the federal senators, every 6 years, and the members of the House every 2 years. So we work for you. You are our bosses. We got the thousands of emails and the phone calls. And I pity those poor people who showed up at the Capitol to testify on some of these bills that we were considering because there was no firm agenda planted. Some of these people came from northern Idaho and had to hunker down for 3 days to be able to get into a conference room, and then they were limited to 3 minutes. So they didn't have enough notice to know when to show up. So this was also a shortcoming of the session. There were no firm agendas to indicate when public testimony would be taken on some of these bills. But I'd like to get back to that issue of they shall have no power to legislate. Okay, we talked about the House concurrent resolution to end the state of emergency. That concurrent resolution goes from the House where it started, goes over to the Senate, does not go to the governor, because I was afraid that it would be worthless if we signed that and it went to the governor and got vetoed. Well, I did some research and come to find out in the joint House and Senate rules, it says that that resolution, a concurrent resolution, not a joint resolution, but a concurrent resolution, goes directly to the Secretary of State. It's a done deal. Once it gets done, the governor has no say-so in it. Now, I'd like to read just a phrase out of Title 46, 1008. This is the statute that gives the governor authority to declare a state of emergency for 30 days and then to extend that for 60 days. Now, I don't know about you, but I think this is kind of a case of Common Core. We're in our 6th month of an emergency. 30 days is 1 month, 60 days is 2 months. We're 3 times that limit. So if we're talking about abidance to the law and the Constitution, what about our governor? Now, I'm not saying that we have to take retaliation and do a tit for tat. You know, he does something wrong, we have to do something equally wrong to protect our rights. But there's a time where you have to draw a line in the sand, and this is the time. Now, I'd like to wrap up because we're running late on time and I'm sure other people want to talk. But the same piece of legislation, 46-1008, that gives the governor the ability to call for that 30-day and then the 30-day extension of the state of emergency is also the same statute that gives us the authority. It says, the legislature, by concurrent resolution, may terminate a state of disaster at any time. Now, to me, at any time means while we're in session. Okay? We were in session in a special session. One more point I'd like to make, and I'd like to read real briefly, and I'll abbreviate it. This is the proclamation that the governor signed on August 19th, declaring or proclaiming an extraordinary session. It's not a special session, it's extraordinary. But he says, at the hour of 10 a.m. on the 24th day of August, 2020, for the following enumerated purposes and no other. To consider the passage of RS 28046 regarding absentee voting during the pandemic. RS 28045 regarding in-person polling locations during the pandemic. And RS 28049 regarding civil liability, and copies of which are attached. House Bill 1 was proposed in the House prior to some of the other bills, or some of the other RSs. They're called routing slips. These are drafts of bills. Guess what? House Bill 1 said that regardless of the state of emergency, every Idaho citizen will be guaranteed the right to in-person voting regardless of the state of emergency or extended emergency. Guess what? That particular bill did not show up on the governor's list of 3 resolutions or 3 RSs. That bill was passed unanimously in the House. We have 20% Democrats. Believe me, on most issues, the Democrats vote against the Republicans. It's just the way it is. Fortunately, we have an 80% majority. It went over to the House, or to the Senate, and it was rejected, or it was voted in favor of by all of the Republicans and all but 2 Democrats. So it was near unanimous in both houses. Now, if we're going to apply the rules of no other bills shall be considered, how did we pass House Bill 1? Exactly. Okay. Shouldn't that be unconstitutional as well? Now, other people will say that, well, it's a modification of something else. Well, all 3 of these RSs revolve around the issue of the absentee or the emergency order. So if we can stretch the House Bill 1 to say, well, it was related to something else, doesn't the state of emergency also fall under that same category, and shouldn't we have the right to do that? I'd like to end my comments by reading something from a very famous person. I get my phone on. Okay. A strict observance of the written laws is doubtless one of the highest duties of a good citizen, but it is not the highest. The laws of necessity, of self-preservation, of saving our country when in danger, are of higher obligation. I swore to support the intent of the Constitution, not to get stuck down in the mud on one particular phrase. This was written by Thomas Jefferson in 1810.
So along those same lines, at least the Senate should have voted on that resolution and turned it down. The idea that leadership somehow can just make a determination that actually we don't want to vote on this, let's do something we can all get along with, is kind of irritating to me. Well, don't want to beat that dead horse. Let's move to the law. Let's move to the law. It appears that I was lied to in elementary school about this equal branch of government thing, this Republican form of government in order to become a state in the nation. The way we address things now is we really do have to ask permission to move ahead. We have to ask permission to come back into session to veto bills or whatever. The governor can suspend statutes. The governor can alter the meaning of the statutes. It's okay. Don't need the legislature for that. The local health agencies, which have this power, they have this power, and they can cite statute after rule to explain why they can mandate masks. But then you go to those statutes, and they don't say anything about masks. You go to the rules, and they don't say anything about masks. So if you're a government agency, all you have to do is attach a statute to what you're doing, and even if it's completely irrelevant, who's going to challenge you? Well, where are you going to challenge them? In court. You're going to gather the funds together and sue. Of course, all of us pretty much are making a living, taking care of our families, taking care of our lives, trying to figure out how to navigate and circumvent these rules that are willy-nilly coming at us. It's not an easy thing to challenge a health district on their mandates. But this is how far America has fallen. Yes. We argue about whether or not it's political to wear a mask, or whether it's appropriate to wear a mask, or whether people are dying all around me. We argue about these things without ever addressing the power that we have given the directors of these 8 state agencies and the individual agencies such as the health districts. This is what has got to be addressed. We talk about what's going to happen next January. There are at least 36 major issues and probably hundreds of statutes that have got to be altered to reestablish legislative authority. When we talk about this Constitution, and it's been read here, it's as though we're not in a republic. It's as though the legislature is here for one purpose: pass a budget. And the weird thing about that is that when we talk about the educational institutions and the curriculum is the question, the curriculum is the issue, the policy driving the curriculum is the issue, the only thing we can do is change the budget. And we may all agree on the legislature that, yeah, the budget has got to be cut, but not enough to affect education. Well, then how do you do with it? What do you do? Cut the Attorney General's budget, cut the governor's budget, cut education's budget. Well, that's what needs to be done. But we can't get that kind of consensus in the legislature because these are important institutions. Never mind that the legislature is working for the benefit of the people. The agencies are working for the benefit of the agencies. So I want to just reemphasize, if it's about the law, then these agencies and these districts have got to cite relevant law before they act. And if they don't have the power, they can't take the power. And it's up to us. Thank you.